Hi, good morning, everybody. I am Alexis Beasy. I am in our Tampa office. I am the co-chair of our class action defense group, and I'm here with Megan Moon.
Hey folks, I'm Megan Moon. I'm a business litigation shareholder in Gunster's Jacksonville office.
So thank you so much for joining us this morning. As you know, we're going to be going over the FTSA and what Florida businesses and businesses that are outside of Florida but do business into Florida can do to mitigate their risk when texting customers. This has been approved for CLE, and an email will be coming out afterwards with all the information that you need to get your CLE credit. And we also have a question function during today's presentation. Please send any questions you think of. If we can get to them in real time, we will definitely do that. It's always more interesting to have an open dialogue, and so we'll try and incorporate those. But at the end, we also have a Q&A session built in, so we'll try and get to as many as we can at the end. And with that, let's get started. Okay, so most of you are familiar with the TCPA, the Telephone Consumer Protection Act. And that is the federal statute that has been the landscape since 1991. And this act, as you know, was aimed at protecting consumers from businesses that utilize an automated telephone dialing system. And that was aimed, at businesses back in the 90s and all the way up to today who were mass robocalling anyone who, sending out those unsolicited fax, text messages. But times have changed, and in particular, text messages have become a common method for companies to communicate with their customers. And the TCPA prohibits companies from sending any non-emergency text message to a mobile phone number using an automated telephone dialing system without the consumer's prior consent. And the TCPA provides for statutory damages of $500 per violation and up to $15,000 for a willful or knowing violation. And in April 1st, 2021, the Supreme Court decided Facebook v. Duguid, resolving a long-standing circuit split on the definition of an automated telephone dialing system, so sometimes called an ATDS under the TCPA. And this decision was really important because it narrowed the interpretation of autodialer as the capacity to store or produce numbers using a random or sequential number generator. And so Facebook's win sparked outrage from Congress and consumer advocacy groups within hours of its release, aided by the Supreme Court's commentary that number generation and perhaps the TCPA itself is outdated. The original authors of the TCPA and others denounced the decision and threatened legislative response, which brings us to Florida and what Florida did as a result of that decision.
Yep, as Alexis mentioned, it's important to understand the TCPA as background for the FTSA, as folks lovingly call it, the mini TCPA. So Florida has obviously had the many states were looking into the reaction from this Facebook decision. And really what happened here was a lot of Floridians started complaining to their representatives about robocalls. Apparently this is the one thing Floridians are united on. They hate telemarketers. They don't like robocalls, spoofing, spam calls. So Florida had a telemarketing act similar to the TCPA since 1990. But really the predecessor to the now FTSA had no teeth, really related to licensure for commercial telemarketers, regulating their script, how they identify their business, really aimed at telemarketing fraud, right? So really there was no private cause of action there. In response to the Facebook decision, and plenty of our representatives apparently getting calls from Floridians about spoofing, the legislative history on the FTSA shows that these types of calls are really the ones that the statute is designed to protect. The legislature recognized that there were other legitimate and legal use of technology that they're regulating, but they really took a broad brush here with the FTSA. This is in April of 2021. The House and the legislature unanimously voted to amend the FTSA. It got a big facelift. Many significant changes, which we'll talk about today. I say this with love. In large part, the legislator made it very confusing. It is a very vague statute, and we will certainly go over the implications of that. So with the amendments that are effective July 1, 2021, the legislator really gave the FTSA teeth. It imposed a private cause of action for most of its sections, which we'll go over. It created very strict opt-in requirements, very heavy penalties for telemarketers of consumer goods and services to Floridians. So this, as Alexis mentioned, this includes not only Florida merchants, but any non-Florida business that is making sales calls or sending text messages to any Florida resident or person in the state at the time. So what changed here with the new FTSA? We're talking about Florida Statute 501.059, and the answer to what changed is a whole lot. The new act requires any person making a telephonic sales call, including sending text messages, using an automated system to obtain signed, prior express written consent from the consumer. That's a mouthful. It's a mouthful under the statute. There's a lot of definitions under there, a lot to unpack, and Alexis and I are going to take that in turn. But I wanted to call your attention to a few items out the gate. First, we're talking about regulating telephonic sales calls. That is defined broadly to include calls, text messages, and voice messages, right? Voicemails, pre-recorded messages, those all count. The statute covers calls and texts that are made to a consumer, which is an actual or prospective purchaser of a recipient of consumer goods and services. Now, again, we're talking about a Florida statute, so that consumer needs to be a Florida resident or in the state of Florida at the time of the call. But here's the kicker. The FTSA, ever broad, contains a rebuttable presumption that a sales call or text made to any number with a Florida area code is in fact made to a Florida resident or a person in Florida at the time. The call has to be made for the purpose of soliciting a sale of any consumer goods or services, or an extension of credit for consumer goods or services. The Act also vaguely covers scenarios where a call or text is made to obtain information that may be used for those purposes. So again, it's very broad. That certainly begs the question, which I'm sure some of you are already popping into your brain. Well, what are consumer goods and services? The definition is what you could expect. It's real property or personal property, tangible or intangible, that's normally used for personal, family, or household purposes. Unfortunately, this is not limited to, what you would think, like cleaning supplies and household items. This definition is untested. The bounds of what is and isn't included is still very much up for interpretation, but suffice it to say, it is very broad. It will arguably capture any effort to make a sale of goods or services, period. Right? So if you are contacting someone that could arguably lead to you making money off of a good or a service, the FTSA would likely capture that. There are very few cases that have addressed some of these definitions, and in federal court here in Florida, the court recently held that even dual purpose text messages, so if it's part telemarketing, part not telemarketing, that's not going to save you under the FTSA. Third, the Act refers to a consumer as the called party. That's a new definition, and it has to be the regular user of the telephone number receiving those sales calls. We'll get on that more in a moment. And finally, very importantly, what's a very tricky piece of the statute that Alexis is going to elaborate on, these are all calls or texts made using an automated dialing system.
All right, so one of the big differences here is that the definition of auto dialer is broader than the TCPA. And this is really important. What we talked about coming out of Facebook, the Facebook decision, is that because an automated system was defined as something that had to essentially generate a random number or store a random number, it meant that if you had a customer contact list, then you were calling somebody off of your customer contact list, that would not be considered using an auto dialer, right? The auto dialer idea after the Facebook decision was that it had to be one of those systems that's just like spinning and like 55555, whatever the next number is on the system. So Florida, when it amended its statute, it changed the definition to an automated system for the selection or dialing of telephone numbers or the playing of a recorded message. And that or is what really becomes the tricky part here, because the selection, it would seem to apply to customer contact lists. If you're using, a mass, CRM database, if you're using a third-party vendor, some businesses have it in-house, but essentially you're collecting somebody's phone number through an ad campaign, through your website, and then you're dialing from that. That would be an automated system. And so this is much broader than the TCPA's definition. And we're seeing a lot of businesses get caught here because they're in full compliance with the TCPA. And then they text somebody, with a Florida area code, and turns out they are now not in compliance with the FTSA because it's not, they're just two different definitions. Okay, so what is it here? It's informed consent, and this is also a feature that is different from the TCPA because it sets out specific requirements for obtaining prior express written consent. And under the statute, prior express written consent means a written agreement that bears the signature of the called party, clearly authorizes the delivery of a telephonic sales call using an automated system for the selection or dialing of a telephone number, the playing of a recorded message when the connection is completed, or the transmission of a pre-recorded voicemail to the called party. And it must include the telephone number to which the call may be delivered. And we're going to go into how you collect informed consent a little bit more. But this is really important. Strict compliance here is required for the FTSA. You need to maintain a record of your consent. This could be through your vendor. This could be, through you internally. But because it's tied to that signature piece, what we're seeing, and we're going to talk about signature a little bit more, is plaintiffs are testing the signature. Again, it is our position that it does not require a wet signature. But plaintiffs are going to say, and we have seen them say, oh, but we've got you now because you didn't sign it. What does it mean to sign something? And so, sometimes companies are just collecting your mobile number, and that may not be enough under the statute. That hasn't been tested yet. But, we would recommend at this point, maybe, at least, an email address or name, something that you could tie it to a signature. But again, this has not been tested yet. In addition, the written agreement itself must contain two clear and conspicuous disclosures to the called party. So we went over the first one, which is that, by executing the agreement, the person has to authorize the placement of the telephone call. Again, this hasn't been tested yet, but we don't think you have to have the exact language here in the first bullet point, but you should make sure that the consumer knows that, one, they're executing an agreement. They're not just signing up for text messages, they're entering into an agreement, and that they're authorizing the use of an automated telephone dialing system. So it's not enough just to say, we'll send you text. It needs to be clear that they're signing up and consenting to receive automated text. And then you have to make it clear, obviously, that consent is not a condition of purchase. And there's
Alexis, do you think it's important to include the word automated given the changes to the FTSA?
Yes, you should definitely include automated. We really want to make it clear that this is a system that may or may not be automated. You may be sending personalized messages, but sometimes you're also going to be sending automated, and I think it's better to cover your bases and mitigate risk where you can. And then let's see. When we talked about how you obtain express consent, but it's important to clearly indicate an affirmative agreement. Remember, you're getting somebody just like you would in a business situation. If somebody's signing an agreement, you need express consent here. We will go into how to collect it, but a check mark is going to be your best bet. Clicking an I agree something that is affirmative. Do not leave the button pre-checked. Those usually are not, making somebody uncheck the box is not as good as making somebody check the box.
And we'll get more into that in a moment, getting down a little bit more into the details of what an opt-in or the consent would look like. But let's just revert back to the statute so you understand what the penalties are if these boxes aren't checked, pun intended, and a person or an entity violates this prior express written consent requirement. There are very hefty penalties. These are just like the TCPA. The FTSA imposes a penalty of $500 per violation. That means per text message or per telephone call, right? And treble damages are also available for what could be found to be willful or knowing violations of that provision. We're talking here up to $1,500 in that case per text message. Imagine, and even in the cases we've seen, we've got vendors that have sent in the tens and thousands, sometimes the hundreds of thousands of text messages to their prospective or actual consumers. And so as you can imagine, these can really be bet the company type damages. So this statute really got a set of teeth here with these amendments. And because the amendments to the solicitation section were not enough, the legislature also amended more of what we call the marketing section. The FTSA imposes further restrictions regarding when and how many texts or calls can be sent to consumers. The new bill reduced the hours during which consumers can be called or receive text messages. Used to be 8 a.m. to 9 p.m. Now it's 8 a.m. to 8 p.m. in the consumer's time zone. Our Panhandle folks on the webinar today will know that Florida encompasses 2 time zones, right? The Western Panhandle is in Central Time Zone, while the rest of the state uses Eastern Time. So that means companies or the vendors that they're using or persons who are texting into Florida need to be very careful to know either where their consumers are, which is really a hefty task, or better yet, to err on the side of caution and impose a blanket prohibition of calls and texts after 7 p.m. Central, 8 p.m. Eastern Time. One of the questions that came up in regards to this is, well, what if you sent it at a certain time, but the person didn't receive it until after that time? Unfortunately, the onus on that is going to fall on the texter. If your vendor, pushed these messages out and hit send from their system, but they did not go to the recipient until after the deadline, then unfortunately that is going to be a violation. So again, really, folks, texting Florida consumers need to err extremely on the side of caution and give those text messages or those calls time to be placed. So in addition to the time limits here, the FTSA further prohibits telephone sellers from calling a consumer more than 3 times over a 24-hour period about the same subject matter. Importantly, this prohibition applies regardless of the phone number a salesperson is using to call, right? So you can't just say, oh, I called you from this number and then I called you from that number. That's not going to cut it. That same subject matter, again, is fairly untested. It's going to present an issue of fact for a judge to determine, but you should assume, particularly here in Florida State Court, that it is going to apply very broadly. And that most of these solicitation texts are going to be found to be the same subject matter. The good news is there's decent TCPA case law out there that sort of discounts the initial opt-in and confirmation text that you get when you first sign up for, ideally when you sign up for these texts. And those may not, we believe they should not count as solicitation and thus not towards the 3 text limit. Again, this is untested, so we say should, but best practices are to be very cautious in that regard. Another question we got was whether or not that private cause of action covers these requirements. The only good news in this regard is that it doesn't. This is a different section of Florida's Telemarketing and Solicitation Act. A private cause of action will not apply here for violation of the time and number restrictions. Of course, nobody wants the government knocking on their door, imposing fines and doing it that way, or certainly, creating a lawsuit just for that. But importantly, the other sections, every single requirement that Alexis and I are going over in the other section, it applies a private cause of action. So there are a number of ways to slip up here, unfortunately.
And one big thing to know is that this is really a strict liability statute. And the area where we see a lot of, I would say, like hot bed of litigation is calls to reassign numbers. And a reassigned number is someone who, like if I originally had the number, I signed up, from company A to get a text message, and 3 months later, I move or whatever, it was a work phone. My number then goes back to essentially like the FTC or FCC database, and those numbers are reassigned in about 45 days. And somebody else gets that number, and all of a sudden they are getting text messages for something that they did not sign up to. This is a big source of legal risk for any company that calls or texts for marketing purposes. The churn rate of cell numbers raises the odds that a caller, a business, is going to unknowingly make a call to a reassigned cell number, and in doing so, they're going to commit a violation of the FTSA. So what does that mean? It means be careful. Really, the best thing is if you are texting a lot of consumers, you should sign up for some type of scrubbing service. The FCC created what is called the Reassigned Number Database, or RND, and it's a national reassigned number database that is developed in part, of course, to assist companies that send auto-dialed text message. And it is updated every month with telephone numbers that have been permanently disconnected. And it identifies, so if your vendor should be able to, I know that a couple vendors do, I believe that you can subscribe yourself, and you can identify when that number has been disconnected. Now, the tricky thing about the R&D database is that it only shows you a snapshot in time for that month. Because remember, if numbers are being reassigned in about 45 days, so if somebody unsubscribes, and I believe the database, you have to report on like the 15th of the month, and so you would run the scrubbing on the 16th, and it'll show you for that day who has been disconnected, essentially. And you would scrub your database, remove anyone who has been disconnected, and then do it again next month. And it should catch everyone, in that chunk who has been deactivated. What it won't tell you is who the telephone number currently belongs to, and it does not facilitate matching telephone numbers back to consumers. So companies who make reoccurring auto-dialed calls have a greater need to scrub their list against either the R&D or some other database over the passage of time. And again, if one of the things is if you decided tomorrow, for example, to scrub your database, like we said, it won't capture all of the past users who have since dropped out or unsubscribed. And so one of the things that Megan and I do when we talk to clients is come up with some protocols for how you want to address all of your customer data. And does it make sense, to have people resubscribe in? Do you want to send an update? Do you want to have, run a campaign? What is the way that you want to think about potentially getting rid of those people who no longer have a correct number and never signed up? Because to be honest, those are the people that are actively looking to join class actions. Just so you know, and if you don't already, if you scroll through Instagram, you Google it, there's plenty of plaintiffs' attorneys saying make a quick $500. It'll take you 2 minutes or less. Send us a text message that shows you never signed up. And most people remember that they signed up and they press stop. People with a reassigned number are like, oh man, this is my chance to make $500. So that, just please keep an eye on that.
Yep, and Alexis really hit the nail on the head. Why are we talking about this statute? Why are we walking you through all this? That is because these cases are pouring in daily. We keep tabs on these cases filed under this act. We've litigated them. We are seeing between 1 and 5 cases filed against Florida businesses and folks who are non-Florida businesses texting into Florida every single day, right? The plaintiff's bar is going, absolutely nuts over the FTSA and the opportunities that it presents for attorney's fees and those per violation damages. There are easily more than 200 cases out there right now, most in Florida State Court, which can be tough for those businesses outside of Florida, and of course some in federal court. And that certainly doesn't even capture the scours of pre-suit demand letters we see, settlement demands, and settlements that have been entered into just as a result of these threats and potential violations of the FTSA. So what does the landscape look like right now? Not many of the cases have gone far enough that we have opinions to provide us with a lot of concrete guidance as to what Florida courts will do, but there are a few worth noting. They really show that courts here vary on their interpretation of the FTSA, given the statute's lack of clarity, and have even reached conflicting results. So you gotta love Florida. One example of that dichotomy, we have a state court case. It's Alvarez versus Sunshine Life and Health Advisors, held that unlike the TCPA, a consumer does not have to suffer actual harm to obtain damages under the FTSA. So you may be thinking, as you know, I did too, well, what, you received a text message, big whoop, text stop back and move on with your life. And the defendant in that case argued that an FTSA claim could not be pursued because they only received 1 or 2 texts. They didn't constitute a concrete injury to confer what us lawyers call standing. The Florida court held otherwise, right? That in Florida state court, at least, to bring an action under this statute, a plaintiff only has to allege that he or she received a text message from the defendant without prior express consent. That's it, right? There doesn't have to be any attendant harm or injury. A simple violation will suffice. You can imagine, ultimately after that decision, this case ended up settling on a class-wide basis for about $2.6 million. So it's very hefty, those per violation risks. Good news though, if you're in federal court here in Florida, the Southern District of Florida recently dismissed or rather remanded an FTSA case for lack of standing, finding otherwise, that it was not enough that the plaintiff said, well, I was annoyed, it invaded my privacy, I was aggravated at these 5 text messages I received, and the court there did find that there was no financial loss or pecuniary harm asserted, and the case was remanded. I won't belabor all of these. Suffice it to say that defendants seem to have better luck on the FTSA in federal court. A lot of these come to the court on a motion to dismiss. There's been attempts to dismiss on the basis that the plaintiffs are not alleging what an automated dialing system is here, or enough facts to suggest that the defendant used one. Those have been fairly successful in federal court, particularly depending on the rudimentary pleading, but those challenges, unfortunately, in state court have been rather unsuccessful, as have constitutional challenges. You may have heard a lot of rumblings when this statute first came out, that folks were like, there's no way, this is undeniably unconstitutional, it's vague, it violates First Amendment. And so folks have made those challenges, and in both state and federal court thus far, there's been a few of those cases finding otherwise. So the statute's here to stay. It is very difficult to get these cases to go away at the pleading stage, right? On a motion to dismiss, before you or your business have to spend a ton of money and obviously suffer burden to get through some of the merits. These battles are going to be fought at the class certification stage, which is a very intense and costly process. Alexis and I have had success here in Florida State Court in having allegations stricken, the class allegations, before the case even gets off the ground. And obviously that's an ideal scenario, but it's not available in every scenario. So better to comply.
Yes, and Megan, we got a question in. I'm going to read it for everyone's benefit, and then we will answer. It says, would a healthcare provider that utilizes an automated system to send calls or texts for appointment reminders be covered? That's a great question. So the way the statute is written, it should only apply to solicitations, right? So that would mean purchasing something. The tricky part comes in is, would you say, how do you qualify an appointment reminder, right? Megan and I have been involved with such appointment reminders where it's tied to, come in today, but your bill also needs to be paid. Something like that starts getting a little bit more iffy. I think that we would say that if it's a pure transactional and it's, your appointment is at 2, click to confirm, that should not be covered. But best practices still always say get consent before sending a text message. And it's really, just have your patient, sign something ahead of time. If they're coming in anyway, it's a wet signature consent form. If, it's an enrollment process online, it's a screen that they can click. It is much easier to just get the consent at the forefront than worry about getting a demand letter or a class action complaint on the back end. Because even if we win at the motion to dismiss stage or get it dismissed, you've still incurred, attorney's fees and time, which I'm sure that you do not want to be doing. Let's see. Okay, so what is the path forward? So the best path forward, as we've both been saying, is compliance. And what does compliance look like? That's going to be clear and conspicuous opt-in language. It's going to be an agreement to terms and conditions, and it's going to be a class action waiver and possibly an arbitration agreement. And the reason we recommend the class action waiver and arbitration agreement is the damages in these cases. It's one thing if one consumer says, well, you texted me without permission and it's $500, right? But what plaintiffs' attorneys are really looking for is a class. And so if you have, 100,000 consumers in Florida, who each got 20 text messages since July, 2021, and more likely though, if you're marketing, they've gotten a lot more text messages than that. Like Megan said, you're looking at a bet the company litigation that's really hard because it's almost a strict liability statute. And so we're going to talk about each of these compliance things in turn. All right, so the first thing we're going to talk about is the opt-in landing page. And this is what we've been talking about, which is the explicit written consent, that you're adding your customers to a subscription list and you're sending them marketing or promotional communications. And I cannot emphasize enough, you have to document and save this consent. Make sure that your consent is clear and conspicuous, that the consumer is entering into an agreement, that the text messages will be automated, and that it is not a condition of purchase. Now, we've talked a little bit about the signature component. Again, it is not defined in the statute other than to say what is acceptable under state or federal law. So, of course, Florida State doesn't really have a clear answer to that. So what we're going to look at is federal law. And if you're looking at the TCPA, the e-sign act should be enough. And this is an affirmative action, such as a check the box to get you to agree to receive text messages. But be careful here, boxes that ask you to do more than one thing have been found to not be a clear indication of consent. What do I mean by ask you to do more than one thing? So if it says something like, click here to get 15% off, that is not clear that you're agreeing to get the text messages. So it should be click here to receive text messages, not click here to receive text messages and get 15% off. Again, you're combining them there, and courts are much less likely to find that you've agreed to enter into an agreement. The next thing is agreeing to the terms. You need to make sure that you're clearly communicating the terms and conditions, and not that the consumer is just viewing them, but that they are accepting them. And so that is a mixed bag here in Florida. There has been some success in arguing that a disclosure that view terms and conditions here has been upheld, but there's cases on the other side which say that is not enough. It really needs to say, by clicking, I have read and understand the terms and conditions. And you should provide a link to the terms in your initial disclosure. And periodically, best practice would be to remind your customers how to access it. So again, if you've been sending text for a really long time, at some point you would want to revisit and say, our terms have been updated, or whatever it is, but click here. Remember, press stop to opt out, again, so that consumers know what they are doing. The next thing is the double opt-in. Okay, so this is where somebody opts in to your marketing program, And they're going to then send a confirmation text to subscribe. And you're going to also provide opt-out instructions, which are the stop or the help if you have them. The reason we recommend the double opt-in is for two reasons. One is it confirms that your consumer really wants to join your text marketing list. Sometimes people accidentally transpose numbers, and now you may have, inadvertently opened the door to liability by texting, what we'll call a wrong number. So when they reply yes, they are signing up, affirmatively agreeing, and it's a great fact to have if you do get a complaint from one of these plaintiffs' lawyers that not only did they sign up, and here's a screenshot of what they signed up for, but here's where they affirmatively texted yes and agreed that they were confirmed. Another tool, and I know some vendors are able to do this, I don't know if all, but it populates the bottom of your phone with a hit send to actually subscribe rather than a text yes. The reason we like this one, if your vendor is able to do it, is then if you have that reassigned number or that inadvertent person, they're not even getting a text message. That would be that $500, initial, strict liability, because they have to hit send. And if they don't, then, you've never texted them to begin with.
Before we move on, Alexis, I have one question, which is, you talked about the opt-in on like a mobile phone or from a desktop. What might a double opt-in look like if you're having folks sign up like in a doctor's office or in person?
Yeah, so actually I've done quite a bit of this. If you're having somebody sign up in person, I'm quite a nerd. I love taking pictures when I see a good one. So when this, there's a few different ways. So there's a vendor that I like to shop at, and I noticed that a month after this FTSA went live, so about August, when I checked out in person at the store, the screen, where you usually sign to for your receipt or whatever it is, had the disclosure in the screen, and you could affirmatively check the little box and then sign to receive text messages. And I did that, and I took a picture. Another way to do it in person is, so if you have somebody, for example, like a car dealership or something else like that, where somebody's coming in, it is just, either you can send an email and that person would then sign up through the email, say, what is your preferred method of communication? And they say text messages. And you say, I'm going to send you an email so that you can opt in, to receive text messages. Or it's just a printed paper and you collect the wet signature if you're in a doctor's office. I know often when I'm in a doctor's office, they have a bunch of forms that initial day, where you provide your insurance card, your agreement to arbitrate, and then you would also sign to receive, appointment reminders. All right.
And we are really in a mobile world. There's a lot of cases out there that are putting some of the onus on consumers to say, look, this is a world of internet contracts. We do these all the time, and so these are going to be enforced if, right? And there's a lot of ifs, and frequently one of the side issues, aside from litigating over whether the FTSA was violated, these big side issues come up when we're trying to enforce the terms and conditions, which typically contain, the protection to the company that we want to enforce, right? So using, we'll talk about ways to enforce those, but first you want to make sure that those terms and conditions are effective, right? That they have, as Alexis mentioned, these things that are going to protect you even if in any FTSA lawsuit. A big one of those is class action waiver. Again, you're not going to find too many plaintiffs' attorneys that are going to go spend all these dollars to get one person, 500, 1,000, even a couple $1,000 off of this statute. What they're really going for are these classes, right? And to certify a class of all users in Florida who receive these text messages from your company without consent, right? Very broad. So a class action waiver in your terms and conditions that are typically contained either on your website or in a writing that the user saw, that's going to be very important. That should go hand in hand with an arbitration provision. The arbitration provision obviously allows the entity to to kick any litigation over to arbitration. A lot of times when we're successful there, we'll see the case just go away. Because again, these plaintiffs, I'd say, these plaintiffs lawyers, folks who are suing and expected to make a big buck off of your company really aren't going to be able to do that there. There's no per se rule in Florida that an arbitration provision has to be disclosed in the initial, look here, or look what you're signing up for, look what you're assenting to. But it's very fuzzy out there. There's plenty of gray area, and texted plaintiffs are definitely making the argument that even if your terms and conditions contained an arbitration provision, you didn't know about it, you didn't receive upfront notice, and that is certainly a process that needs to be litigated, and you hope that the court comes out the right direction. So aside from those two, and one thing I would say when we're talking about using terms and conditions effectively, what we'll see oftentimes is when we're in these cases, and we'll get into them, and they send us what the opt-in looks like, we do it, sign up ourselves and figure it out and go through the process and get that 10% off coupon. We'll realize that there may be a different process when you sign up in person versus when you sign up on your mobile desktop via email versus when you sign up, you're on Instagram, you swipe up, or you send that double opt-in text message. And sometimes one or many of those are overlooked. And so the terms and conditions are squeaky clean and look great for the FTSA on the mobile, but not so much on the desktop or in person, right? So that's easy to overlook in terms of FTSA compliance. And we really obviously do not want to make that mistake. So there are ways to ensure that your terms and conditions are more likely to be enforced, right? There's never a guarantee. Again, these internet contracts are just like other contracts. Florida contract laws apply. There are lots of decisions out there in terms of what a click wrap or a browse wrap or a hybrid wrap agreement looks like, but suffice it to say, we're talking about notice to the consumer that they are agreeing to what you're asking them to agree to, and that it's very clear. So clear and conspicuous is huge. You can see the big fat fingers on the screen. It is very evident that the button says agree, right? They actually have to scroll through or at least look at all those terms and conditions. That's best practice. We definitely understand that marketing doesn't always want to do that. And there are certainly, ways around that, but best practice is basically so that the user has no choice, right? There is no argument that they didn't see it. The test is often one of inquiry notice. The standard is would a reasonably prudent user, be on inquiry notice of these terms and conditions. But again, actual notice is always better, right? That's best practice. You guys may have done this where you've scrolled on your phone and you couldn't actually click the agree button until you had scrolled down to the bottom. You probably do it very, very quickly like I do and skim in 1 second, but nonetheless, that's going to be best practices for this. We're looking for affirmative consent, a check the box, a big bright button that says I agree. As Alexis mentioned, it shouldn't just say agree. Our sample here on the screen, it's much better to have that disclosure. By clicking this button, by checking this box, you are agreeing to X, right? You are agreeing to receive text messages from an automated system, and you are agreeing to the terms and conditions. So again, as Alexis mentioned, sometimes those terms and conditions are just there. And courts have found that, look, there's no tie-in. I see these terms, but there's no tie-in to the act of assent and those terms, and so you want those two to be married. Any hyperlinks to the terms and conditions should be obvious. I do know folks who have actually included all of the terms and conditions on the sign-in page. That is obviously a very good fact and best practices for those folks. So it's a good idea.
All right. Now the big thing here, once you've included your arbitration provision, is to be conscious of unconscionability. So even if the arbitration agreement is deemed accepted by consumers, the big challenge is from plaintiffs, consumers, are that it's unconscionable, either in whole or as to specific terms. And courts still tend to scrutinize arbitration clauses and class action waivers. So online retailers or anyone who's using an online sign-up process needs to ensure that their agreements can withstand the scrutiny. And so what does it mean to be unconscionable? So to evaluate this unconscionability, courts look at whether or not the consumer not only was bound, which is the manifest explicit consent that Megan was just talking about, but whether the consumer is prevented from vindicating his or her rights. And what does that mean? So if a consumer signed up for your services and they just sued you in court, they would pay a nominal filing fee. It would be in their home, jurisdiction where they reside, and it would proceed through that legal process. Whatever their statute of limitations would be, that would be it. Whatever discovery they were entitled to, they would get that discovery. So what happens when businesses put in arbitration provisions? What we see is that sometimes businesses like to make them very one-sided or favorable, and that will not fly, unfortunately, when you're in a consumer disagreement. So you need to make sure that it is very consumer friendly. And so that means, avoiding lengthy legalese. And I like to say this is an opportunity, although not a lot of people click on it, but it's an opportunity to show what your business is about. Like, are you a funny, like hyped up, like whatever, appealing to younger people? Like, if you take a look at some of the terms and conditions, for like a Snapchat or something like that, their terms are actually written in the style, that they're conveying. It's also an opportunity to show that you really believe in your product and in your customer relations. So you can use this opportunity to say things like, we really want you to be satisfied with our product. We would, if you're unhappy in any way, call us first. What are the steps that they can take? So use this instead of an opportunity, to just think about it as a legal contract, which it is. Think about it as a way to win somebody over that might be grumpy and looking at this because they're upset. So then next, explain what law is going to apply to the arbitration. So, you're probably going to pick federal. You might pick state. You're going to provide which set of arbitration rules apply. So they're, JAMS or AAA, we see both of those. Make it clear that they govern, make them available, such as by including a hyperlink to the arbitration rules. And if applicable, say which specific rules are going to govern. And here I like to say, if you're going to use the AAA, they have a consumer set of rules, which is great because by incorporating those in, it hits all of the minimum standards that you need, such as how the fees are paid, how attorney's fees are handled, where the jurisdiction is. JAM doesn't have a set of rules like that, but they do have the consumer minimum procedures, and you could adopt those. Next, you're going to provide consumers with sufficient opportunity to investigate their claims. What does this mean? Don't start messing around with the statute of limitations. Don't cut off discovery. Just let it go. Next, provide that the arbitration will take place where the consumer is billed or resides. So again, that's what we were talking about with the court of law. If you could say something like, if it's a claim, where you'll go there essentially. And the thing that I hear a lot from businesses is like, well, I don't want to go there. I want it to be here. I'm located in Florida. And what you have to remember is if it is a consumer and you've gotten this far and somebody is still pursuing it and your class action waiver was found to be enforceable, you're talking about probably a $500 claim, maybe a $3,000 claim, maybe even a $15,000 claim. And you're most likely going to do it on the papers, maybe a telephonic hearing. It's not something like that you really need to be invested in having it in your office area where you are. Again, I would say also you're going to allow telephonic hearings or small claims court. So you could say something like anything under $15,000 will be, by telephonic or small claims. Again, this is consumer friendly because they may not want to get a lawyer. If they're just pursuing, a $500, telephone call, then they don't need a lawyer, hopefully. But the other thing to remember is this isn't just about FTSA when we're talking about the terms and conditions. This is really anything that a consumer is going to complain about on your website or on your products or anything like that. And it's a great way to get rid of all types of consumer class actions, for anything like, your strike through price wasn't accurate, the color wasn't the way I expected it, it actually does have sugar, get get these things enforceable. And
not a calorie-free gum.
Yes, that these claims exist. And then don't expose consumers to expenses they would not be required to pay in litigation. What does this mean? You're going to pay all or most of the arbitrator's fees and expenses and other costs unique to arbitration for non-frivolous claims. So don't, and if you adopt the consumer minimum procedures or the AAA rules, there's like a schedule, and it says, I think the consumer pays like $250 to initiate, and then the business pays, the rest. You can include a clause, like I said, for non-frivolous claims, you're not going to pay their attorney's fees, but if it is a frivolous claim, you could say, that you're going to seek attorney's fees. But again, that doesn't fly in California, so just be careful. You may want to have a carve out. And the thing I recommend really here is when you're doing your terms and conditions, it really does make sense to have somebody who is experienced in consumer class actions like Megan or I looking at them, because this is not something that you just want to copy and paste from an arbitration agreement that you may be doing with a business, which you can make the terms as favorable as you want with somebody who has equal bargaining power and they're working with their own attorney. So, and that brings us to the end of our presentation and whether there are any questions. So if anybody has anything that they have not already asked, please feel free to enter it into the chat box. Megan, I don't have any right now. Do you have?
I do, and I'll apologize to the user for my technology ineptitude if I didn't see it sooner. But here we go. No time like the present. So this is a very good question. Does the FTSA apply in business to business versus business to consumer sales or business to business invoice due notifications? For example, if this business sends an invoice due to a client or a purchaser, does this require opt-in agreement to terms, et cetera, et cetera? So that's a very good question. And a lot of people freaked out about questions like that when the statute first came out, because unlike its predecessor, which had a whole lot of exemptions that made this very clear, a lot of the exemptions have been withdrawn, right? If some of those included if you've already received an inquiry from a consumer, right? You already have this business relationship. That's very, very useful to folks, like the folks who are asking these questions, and business to business. So we lack that clarity. However, to put your mind at ease, again, this is not, it would suck to get sued and have to be the first to test this, but we would think, given the language of the statute, that business to business would not apply these invoice reminders. Again, the content of what you're saying is going to matter, but remember, all of this applies to text and telephonic sales calls to a consumer, right? And that consumer is defined as a purchaser or prospective or actual purchaser or lessee of goods. I get that your ears are perking up and you're thinking, wait, these folks on the other side of these invoices are going to be purchasing goods. Luckily, the legislature didn't let us down entirely. In a separate section of the statute that defines an unsolicited call, there are certain, I wouldn't call them exemptions, I wouldn't go that far, but the definition excludes if you're responding to an express request, right, of a person called, or in connection with an existing debt or a contract, right, if payments or performance of such debt has not been completed. So that's going to be the linchpin here. I think that's where it's going to save these business to business reminders. They are going to fall under that bucket of existing debt or contract. The key here is that, I would be more wary if that debt or contract has been completed, which is what the statute says. And as you can imagine, that's because we're getting more into the realm of, you no longer have that open invoice, you no longer have that open invoice business or purchase order, and now you're just asking for more business. And so you're really going to start to get closer to that line of consumer. Again, I would hate to see the statute go that far. I think this exemption is going to save those business to business communications, but be mindful that those are in relation to an existing debt, a non-satisfied debt or invoice would be my suggestion.
All right, does anybody else have any questions? I don't have anything else in my queue. So Megan, do you got anything there?
I received a question when we were pushing this out, and one of those relates to, again, there's so many factual inquiries into the type of entities that this applies to. We have seen, unfortunately, educators, universities that are being sued under this statute, and you know, where one might not think, well, this is a consumer. And some of those lines that are drawn are really gonna matter what the text message is, right? If it's, again, it's a reminder to submit your application that you already started, that you already have an express request of the person to get more information about that university or whatever services you're offering. You know, that's a different than, hey, you know, come on out and, you know, we'll waive your application fee, go ahead and apply here. Because again, you're getting closer to the line of, I'm going to make money off of goods or services that I'm providing you. And we do think the FTSA is broad enough to capture that. So unfortunately, we're not seeing educators or other government entities that are avoiding this. We're seeing a lot of telecommunications companies. And when I say we see, again, these are 1 to 5 businesses a day that are getting sued. And even if you win on one of these exemptions, you would you know, be very glad to do the work on the compliance on your terms and conditions on the front end. That's going to save you a lot of legal fees to be, even if you're right, you know, it takes money to be right, as we all know. So it's better to comply on the front end, and that's where we've seen the best practices come into play.
Yeah, and just to echo Megan before we close out, in terms of compliance, so we also get a lot of demand letters on behalf of, you know, from our clients. So they're getting demand letters from plaintiffs before they file the lawsuit. And I've literally had, you know, maybe 5 of those in a week from the same plaintiffs firm. They're just, you know, sending them out. And when we can show, hey, look, they signed up, there's a class action waiver, and they accepted the terms, not that they viewed the terms, we really never hear from the plaintiff's attorneys again. So that the moral of this story is, do not be the low-hanging fruit. Get in compliance, and if you need help figuring out how to do so, you know, we're here. So I think with that, we shall bid you adieu, I guess, right?
No further questions, Your Honor. Thanks, folks. We appreciate you. And again, if you do have further questions and you're too shy, or like me, probably can't figure out the question box, you know, you can see our information here, know where to find us, and we're glad to answer any questions that you have.